Good afternoon, everyone. Thank you so much for joining us today. We are going to be talking about FMLA, ADA, workers' compensation, and paid sick leave. I am Christy Weierbach. I have Lois Ribner here with me as well. She's going to be helping with the polling questions and interject some feedback as we go along here throughout today's session. And before we get started, we will review a little housekeeping items. First of all, at the end of this webinar, please complete the survey. For many of you who have joined us previously, you're familiar with this process. For those of you who haven't joined us previously, welcome. At the end of the webinar, you will be provided an opportunity to complete a survey, and the purpose of the survey is really for us to gain feedback on what you liked, what you didn't like, maybe some topics that you would like to see talked about in the future. So please complete that survey, and upon completion of that, you will be put on the list to receive your certification credits. So those usually are sent out within 1 week, and you'll definitely get those. I know we did receive a question already through the chat box about that, so yes, you will get your credits within 1 week after the webinar. Should you have any questions as we proceed, feel free to enter them into the question and answer session. Lois will be monitoring them, and as long as time permits, we will go ahead and answer those throughout the webinar. However, if we do see that we're narrowing down on the time, we will follow up with you separately after the webinar. And certainly we have built-in time at the end here, 5 or so minutes, to be able to answer some of those questions that you may have. So we'll go ahead and get started. The purpose today of this webinar is that we received a lot of feedback over the past couple months about clients wanting to learn more about FMLA. So this is truly the opportunity for us to dig deeper into that topic, as well as talking about ADA, the American Disabilities Act, and how close they are with FMLA, and you'll see just how fuzzy those lines can be. We also wanted to extend the conversation to talk about workers' compensation as well as paid sick leave. So we do have a lot of content in here. This session is focused more for beginner to mid-level. We're going to provide you an overview of some of this legislation, as well as give you tips and tricks and just some helpful hints as you navigate through maybe an employee who has to request time or accommodation as a result of illness, injury, etc. So the first poll question that we have for you is, I want to know, how comfortable are you with FMLA, which is the Family Medical Leave Act, and ADA, which is the American Disabilities Act? Do you feel good? Does it cause you some confusion? You just aren't sure about the two of them? Or do you have no familiarity with these two topics and you're here to learn more about it? So as soon as we get to 85%, we will go ahead and release those results. And we're just about there. Need a few more of you, so we hit it. Okay, Lois, can you tell us what the results look like?
Sure can. It looks like we have 34% who feel good, and the great majority, 60% of you, are in that dazed and confused stage, and not at all. There's another 6%. So, Christy, you're here to help everybody to get out of that state.
Yes, absolutely, and that is completely normal to feel that way about these topics, because they are so intrinsic and so detailed, and certainly there's no possible way for you to memorize everything about them, but to know exactly where to go to find information when you are faced with a situation like this, or to be aware of how to recognize when an employee may need to lean on these legislative requirements. So, as I indicated in the beginning, there are fuzzy lines between these two core topics. And so I wanted to highlight a few areas where you can see how they would become blurred. The first one is that, interestingly, the EEOC will receive claims of discrimination. And as a result of that, when they conduct their investigation, dig a little deeper, they find that really there's issues from an ADA or FMLA perspective. And when that was pointed out to me, I thought, wow, that's really powerful. So employees may terminate or, during their employment file a complaint because they feel that you're just not being fair, they're being discriminated. And here it ends up being something related to a disability or maybe an illness, injury, etc. And I participated in an employment law seminar earlier this year, and they pointed out that current illegal drug users are not covered. However, if they are a former user, they've gone through rehabilitation, they are covered under the ADA, which was quite interesting. And alcoholics are covered, and certainly alcohol is not illegal, and I think that's why alcoholics would be considered covered and not fall into that category of an illegal drug user. So that was quite interesting. The state of Pennsylvania, I participated in a webinar. They reinforced this point, so it was just interesting how closely those items are, yet so very different when you're looking at the legislation. Similarly, if we look at pregnancy, it is covered by FMLA, but not ADA, because pregnancy in and of itself is not a disability. However, should something arise, a complication come up as a result of the pregnancy, maybe post-traumatic or postpartum depression, that certainly could potentially be covered by ADA. And we're going to hopefully help clear this up a little bit for you and bring it more into focus, because we definitely want you to be prepared to navigate through these blurred lines. And if I step back and I take a look at some of the themes surrounding these two core items, if you will, and it does translate into the workers' comp, is that you need to really understand the eligibility, who is eligible and who is not for these legislative requirements. What are the responsibilities of you as the employer, as well as what are the responsibilities of the employee? You need to have pristine tracking, and you also need to make sure that the proper notices are sent out timely and to the right parties. So we will dig into those deeper as we move forward here. But I found a neat little tool here, and certainly I know you can't read it. It is here just for illustration purposes. I have the website here, so you can go ahead and download it at your convenience, because it's a great map that you could post in your office, and we're going to talk about this further on the next slide, so please bear with me. But this essentially is a great roadmap for how to proceed with FMLA. And you will get a copy of this presentation, so don't feel that you have to write down this website. It will be made available to you. So essentially, what that map is saying is that there's 11 steps that you should take in the FMLA process. And as we move forward on the future slides, we'll talk about the different parts of this legislation. But first, you have to decide and determine if you're a covered employer, and we'll talk about that moving forward. You have responsibilities to display FMLA posters and to provide general notice to your employees about whether or not you are a covered employer. You may or may not hear a direct request from an employee, but you also have to be able to recognize when there might be a request pending and the employee's just not communicated it to you yet. You have to determine whether or not an employee is truly eligible to be covered under FMLA. You need to provide notice of their eligibility, whether they are or aren't eligible, their rights and responsibilities surrounding FMLA. You might have to request certification from their doctor to verify that they truly do have a qualifying injury or illness. You may have to then provide a designation notice to them, letting them know that yes, you have approved their request for FMLA leave, and then you have to be able to grant them that leave and keep track of it. Through this whole process, you have to maintain their health benefits. And then at the end of the leave, you have to restore that employee potentially into a position that they left or an equivalent position, and we'll talk about that more on a future slide. And throughout this whole process, you have to maintain proper records, because that is key and critical that you do have the proper documentation in place. So this is a little roadmap. Hopefully you find it helpful. That picture is a great illustration for you to post in your office, and certainly as we move forward, you'll gain a greater understanding of these different areas. So essentially, the Family Medical Leave Act, for those of you who are not familiar with it or still a little fuzzy, is that you do have to provide unpaid leave potentially to eligible employees. But it's only for specific reasons, and they're all listed here on this slide. I'm not going to read it word for word, but you may have to, if you're a qualified employer, provide 12 work weeks of leave in a 12-month period. One of the easiest scenarios to walk through is an employee who has a baby, they're off for 6 weeks, and then they return at the end of that 6 weeks. Maybe they have to go out a couple weeks earlier because they're having some complications, and at the end, maybe they had a cesarean, and they have to take a additional 2 weeks or so forth. So this legislation allows them to take that time off. You don't have to pay them, and we'll talk about paid sick leave as we move forward, but essentially, this could also apply to service members, it could apply to family members, and so forth. And this list here is right from the DOL's website, and I have that website down there for you so you can read all the details at your convenience. So essentially, if you're a private employer and you have 50 or more employees, you will have to honor the FMLA. You are a covered employer. And this has to be within a 75-mile radius, and all those details are out there on the DOL's website for you. If you're in a public agency, it doesn't matter what size your employee count is, you do have to provide FMLA leave if it's required and if the employee meets the eligibility requirement. And then as far as schools, they are covered as well, such as your elementary schools, secondary schools, etc. Employees, the way that they determine their eligibility is that they have to work for you, that you're a covered employer. So if you do not have 50 employees, then you do not have to provide this, and they would not become eligible because they work for a company that has less than 50 employees. This individual also has to work for you for at least 12 months, and in those 12 months they have to work 1,250 hours of service. And that's consecutive right immediately preceding the requested leave time. And as I indicated on the last slide, this has to be a situation where employees work for a company that has 50 employees within 75 miles. So let's just say you have 4 entities. You have 10 employees in California, 10 in Texas, 10 in Pennsylvania, and 10 up in Maine. Those individuals would not qualify potentially because they don't work at a facility that has 50 or more employees. Your responsibilities are to send out the required notices, and we'll talk about what those notices are. You need to restore that eligible employee back to his original job or something equivalent. So let's take an architect, for example. An architect comes back and they were working on specific projects. You have to bring them back into a role where they would still be performing the same duties as they had previously, but it might be on different assignments or a different territory, etc. You could not put them out at the front desk and ask them to be a receptionist. I know those are kind of extreme examples, but it demonstrates the difference between an equivalent position and a not equivalent. You also, during the time that the individual takes off, sometimes it is consecutive, just like with a pregnancy. They may be out for 6 weeks straight. But in other cases, you may be faced with employees who need intermittent leave. And that might be due to a serious illness. Maybe they have kidney stones on a regular basis, or maybe they are going through cancer treatments, etc., where they may have to take an hour off here or there, a couple times a week or just a couple times a month. And so we'll talk about some tips surrounding that tracking of the time off, but it's very important that you do that not only for your reference, but also for the employee's reference as they narrow down maybe on those 12 weeks that they might be running out of time. So here is a list of the notices that you need to be aware of and familiar with. This is on the Department of Labor's website. So you do have a notice of rights and responsibilities. So an employee comes to you and says, hey, I need to take some time off due to illness, and I qualify or think I qualify based upon the type of illness. You need to give them this notice and let them know that these are your rights and responsibilities. And don't feel that you have to go out and create your own form. Certainly I don't do that. I go right to the Department of Labor and I print off WH-381 and I hand it to them. So they have the forms out there, they're approved, use them. Don't waste your time trying to create something unique to your organization. You can if you want to be creative, but it's not necessary. Then the employee has a responsibility to obtain certification from a healthcare provider if you request it, and that would be Form 380. And depending on if it's for them or for a family member, it would be E or F at the end of that number. And then individuals who are requesting time off due to military-related reasons. Here are the different types of forms that you'll need to obtain, depending on, whether it's just surrounding the military leave, if it's an injury, illness, if it's a veteran or covered service member, etc. These are the forms. And the forms do a nice job of talking through those different scenarios and which one would be most appropriate for your situation. Health coverage, I indicated you need to carry that through while an individual is off on FMLA leave, and you must still contribute as you did previously when they were actively working. So it's not like you can make them now pay 100%. If you contribute 25% on a monthly basis, you need to continue to do that, and don't treat them any differently because they have taken time off, and just continue their coverage. Certainly if they get the FMLA leave and they indicate they will not be returning, that's when you potentially may issue them COBRA, but that's a situation that needs to be looked at case by case. For tracking, one of the critical pieces of FMLA tracking is just being aware. So if you are an HR representative or somebody that's not at the facility where your individual is taking time off, you may not be necessarily aware each period of time they're out, whether it's an hour here or there or full days, etc. So just having an awareness of this individual and the time that they are missing due to FMLA. You want to be able to implement a reliable system. Certainly there are robust technology solutions out there to help you track that. Could be tied to your time and attendance system, but a spreadsheet will do. So whatever works for you and your organization and your budget, feel free to do that. I just recommend having something ready for the time when an individual requests FMLA. Be consistent. So I can see where an individual, you might want to be nice and compassionate and, oh, they're just going to run over here over their lunch hour for a doctor's appointment. And that turns into an hour and a half or turns into 2 hours. You want to make sure that you're consistently monitoring and tracking that, because you could potentially, not saying somebody would want to do this or intend to do this, but they might try to abuse your compassion with taking time off. So you definitely want to track it, because there might be business decisions you have to make as a result of this individual missing time or leading into another type of legislation such as American Disabilities Act, which we'll talk about shortly. And making sure that you track those milestones, making sure that, as they're getting close to missing 12 weeks, you want to inform them, let them know, hey, you are, coming down to the end of the amount of allotted time, and then let them know how that impacts them. And depending on your employee's situation, you might make a decision to let it extend 1 more week if you feel that truly that 1 week is going to be very beneficial. Or if you see no end in sight, well, then you may just have to make a decision to say, hey, we'd be more than happy to hire you back at the end of the time that you need, and so forth, but you may not be able to guarantee them the same position. So should you at any point in time deal with a situation you're uncomfortable with, I'd be happy to talk through that with you. Sometimes you might actually have to get your lawyer involved to make sure you're making the right decisions should this proceed to the courtroom, which we're hoping it won't, as long as you're doing everything that we're recommending here, but it's not 100% foolproof. So before we do the second poll question, I want to see, Lois, are there any questions that have come into the question and answer section?
And actually, I see one. There's more than one.
Okay.
Okay.
Well, why don't we list the poll question? We can
Okay.
take that. We'll monitor the questions that have come in and take a few moments to answer those. So the poll question I have here on the screen is, I'm curious as to whether or not you have an FMLA policy, whether it's a separate document that you have or whether you have it incorporated within your handbook. So indicate yes, no, or you're just not sure. And we'll look for 85% to complete that, and then we'll take a look at these questions that have come in.
Okay, and we are there.
Great. What are the results?
So the results are that 69% do have an FMLA policy, 18% do not, and 13% are not sure.
Okay.
So let me look here at the poll question, at the questions. I keep going away. there's a little tiny screen where the questions show, so that's where we're having trouble. So if the company has less than 50 employees, the FMLA doesn't apply?
That is correct. If you have less than 50 employees, the FMLA does not apply to you and your organization.
And then another one is if I have 50 plus employees within a 75-mile radius in New Jersey, but I have project sites in Connecticut and Georgia that have less than 50 employees, will only the New Jersey employees be eligible for FMLA, or will it be the company-wide because New Jersey meets the eligibility requirements?
I guess I would need more information to truly analyze that situation, and a few things that I'd like to just pose out there for you to think about. Certainly we can connect at a later time, but are there physical locations in each of those states? Is it a permanent assignment, or is it a more temporary where this individual could truly be an employee of the New Jersey facilities and then would be covered? But if they're permanently located in Connecticut and it's not within that 75-mile radius, they may not be eligible for that FMLA, because that individual, if they were to go out on leave, it could probably disrupt your business in that area, and I think that's why they have that rule and parameter in there. And so I wanted to elaborate on that first question, that if you have less than 50 employees and you don't have to adhere to that FMLA, you certainly could allow the employees to take the time off, but you don't have to guarantee that they would be returning to a position that they had or to an equivalent position. So just wanted to extend on that. And we'll take one more question here before we move on, because I want to make sure we have enough time.
Okay. Is an adult employee who is not the primary caregiver covered by FMLA if they want to take leave to spend time with their terminally ill parent?
Yes, they would be able to go spend time with their parent. You may just have to get the certification that it's a requirement that they be there for the duration and so forth. So what I would do is get more information from the employee, have the healthcare provider certify. So if a healthcare provider does certify that it is truly qualified FMLA leave, then you have to honor it if you have more than 50 employees within that 75-mile radius. That's another scenario that I'd like to get more information to really firm up my position and my advice to you as to how to proceed. So we're going to move on. I thank you for your questions. They're great questions. I always encourage questions because others may have a similar situation that they can relate to. So the reason I asked that poll question is because according to SHRM, which is the Society of Human Resource Management, they said that one of the top 11 mistakes that you can make is not have an FMLA policy. So for the 18% or greater that do not have a policy, or you're just not sure, this is something you want to work on and put that on your to-do list for this year. Get it done sooner than later, because you just don't know when your employee is going to come forward needing that time off. The other items on here that they say are big mistakes is counting light duty as FMLA. You cannot do that. So if you currently do, stop it. Silent managers can definitely be a hindrance to you. So remember I mentioned about awareness. It's important that you and your managers are openly communicating, and that the managers are truly educated and understand their role and responsibility for their direct report or employee. Or maybe they may see an employee in another department that could potentially have not communicated they need leave yet. Maybe they just heard conversation over the water cooler. So definitely making sure your managers are aware and trained so they know how to handle employees who need time off and what that could potentially do to their business operation during that time that they're away. Missed notices, so if you're not doing it timely, each one of those forms that I shared with you earlier, they do have specific dates that you need to, or time frames I should say, that you need to send them out, get them back. Employees have to meet certain deadlines, so adhering to those deadlines is very important. I will caution you that sometimes you might want to be just a little gracious with those deadlines, because if you're trying to be flexible and give your employees another couple days, that definitely will shine brightly. Should a complaint come against you, it'll look like you were trying to do the best of your ability to help those employees. Overly broad coverage, incomplete certifications, those definitely will get you in hot water if you're not tracking the use, because maybe you're going to have to prove that that individual did use all of their time, and if you're not tracking it, then you're going to have a hard time defending that. You certainly may have to modify some sales expectations. Certainly an employee can't be held to the same standard of sales revenue, such as like a car salesman, if they're not truly there all 30 days of the month or the 20 work days, whatever it may be. And you also, like I said, you can be compassionate, but you also don't want to be too flexible, too kind, because it could get you in trouble. And then leading us into the next topic is the ADA and the relationship between a disability and FMLA leave. There are many other types of legislation out there that could potentially cross over, if you will, to family medical leave. So HIPAA, that's making sure information that is submitted on those FMLA forms is kept confidential, because you will have potentially health information or social security numbers, etc. So treat that information with care. We'll get into the ADA in a few minutes. PDA is not public display of affection. That is the Pregnancy Discrimination Act. COBRA, that is if an individual comes to the end of their FMLA leave, you may have to send out COBRA notifications. USERA is surrounding military, and then workers' compensation, which we'll allude to later in the presentation. So the American Disability Act, unfortunately, and I do apologize, I know there's questions coming in and I just need to get through the material. We'll do the questions at the end. I am not ignoring you. I do apologize. But unfortunately, there were 37% of lawsuits filed related to the ADA. That's a significant number, and that's in 2015, so it's a very current number. Keep that in mind as we move forward. But the general intent of the American Disability Act is just to make sure you're not discriminating against people who are either applying for your organization, that you're hiring, maybe terminating, promoting, or training. So we definitely want to be kind to those with disabilities and know our responsibilities as well as our rights, because there may be cases where we just can't accommodate. And so knowing how to proceed when there's an employee with a disability that just would not work well within your organization. And through the decisions that you make, it's important sometimes to seek out advice from an HR professional or a lawyer, because you want to make sure that your employees are not marginalized, isolated, or treated with disrespect through any of those decisions that you have to make, because some of them may be very difficult decisions. There is a website, and on the federal level, it's called the Office of Disability Rights. It's a great resource and tool, so you could continue your research after this webinar in this area if you have specific questions that we don't answer. Disability is not just physical. I think a lot of times we associate disability with somebody in a wheelchair maybe, or somebody with a cane. It is not. It could go so far as with vision, hearing, eating, sleeping, walking, lifting things, bending over, speaking, breathing, learning. I mean, there's really a broad area that is covered by disability, which is really alarming, because everybody does these things, and just being able to recognize what's considered a disability and what's not. Thought it would be helpful here to provide a few examples of what would be considered a disability. And all of this information was obtained from the American Disability Act website, ada.gov, so you can verify what I'm putting here if you don't trust it, but it is credible information and it's true. So anxiety, depression, post-traumatic stress disorder, individuals coming back from the military, these are all items that are covered under the ADA. As such, as you are going through your hiring process, I wanted to point out a few do's and don'ts. When you are in the pre-job offer stages, so you've interviewed somebody or potentially setting up an interview, you see that they come in with a cane, you do not want to ask any questions about that disability. You don't want to request medical examinations because they have a patch on their eye. These are things that you cannot do and don't do. Now, if they voluntarily offer information, I was in the war and ever since my knee just doesn't work the way it used to, certainly, you can write that information down and just kind of tuck it away, but you cannot ask specific questions, cannot ask them to elaborate further, etc. Now, once you do offer them the position, you could ask them disability-related questions because you might have to accommodate that disability. Do they need a chair at their work site because they can't stand for long periods of time? And you might have to have a medical examination done because if you're in an industry where they have to work extreme temperatures, out in a warehouse, that could potentially hinder their ability to breathe, and you might have to accommodate them taking breaks to an air-conditioned room or something like that. You just want to be consistent, so it has to be a question or a medical examination that you would ask others who are working in that same job category. So being consistent is key in this area. We are going to ask you our last poll question. It's important that we get that 85% participation. This does also feed into the certification, so need you to answer those if you want your credits. But do you believe that a person's supervisor, a request to change that is a reasonable accommodation under the American Disability Act? Yes, no, or not sure? And on the next couple slides, we will be talking about reasonable accommodation, just in case you're unfamiliar with that is. And then I will answer this question as we move forward on the slides.
All right, we have results. We
Great.
have 19% say yes, 43% say no, and 38% say not sure. So, Christy.
Okay, great. And I'm going to just hang on to that for a minute or two as we go through the slides, and I will answer that. I promise you. Give me about 4 slides. So a reasonable accommodation is any change in the work environment or the way things are done that enables your disabled individual to enjoy equal employment opportunities. So you might have to make some modifications within your organization, but don't panic because you'll find out on a slide in a couple here that there are specific things that, are not considered reasonable, and you definitely could defend not making modifications based upon that. So the ADA handbook here for small businesses is a great resource that you can do additional research here. EEOC website is very great, user-friendly. I enjoy going out there and doing research when I need to if I'm faced with a specific example or situation. If you have an individual that comes forward and says, hey, I need you to provide a reasonable accommodation, there is an interactive process you can follow. And this is critical that you do this because should your employee go file a discrimination case with the EEOC, as we talked about initially, and they find that maybe it's potentially a violation of the ADA legislation, you may have to justify the decision that you made to let them go or to not accommodate their request. And through these steps will help you make sure that you're documenting and gaining all the information necessary to determine if they truly are being reasonable with the request that they submitted to you. Because certainly the government recognizes that companies can't be faced with an undue hardship. They don't want to jeopardize your business. However, they also are going to be employee, lean towards the employee side to make sure that they are given the best opportunities to work, out there. So first, you want to better understand what is their job purpose and the essential functions of their position. Knowing that truly and assessing whether or not that they can fulfill those responsibilities is important. You should not make that determination. You should lean on the advice of a medical provider for them to certify whether or not that individual can lift 50 pounds regularly or can work in temperatures up to 90 degrees, etc. You do want to ask the employee questions about what are their limitations and what is the nature of their disability. And this is where you could, if the employee submits information and you're like, you know what, that just doesn't sound right, you could reach out to their healthcare provider and get them to elaborate on what the employee is explaining. or to confirm that it is truly legitimate, because you do want to verify that they truly do need some accommodation so they can perform their work. You want to understand, is this going to affect your business on a straight basis, like consecutive, couple weeks at a time, or is it going to be sporadic and maybe just affect 1 or 2 hours here or there every week or so? You want to understand, how long is this going to take? Are they going to need time off, or is it really just a 6-week period of time where they heal their knee because they were playing golfing, etc., whatever the case may be. And the theme through this should be find out as much information as possible and gain a greater understanding of the accommodations they're seeking, so that way you know what you have to provide and what their request is, and if there is some misalignment there, you might have to dig deeper. Throughout this whole process, it doesn't hurt to get your lawyer involved. I think proactively getting them to help you through this interactive process will be far beneficial than trying to retroactively gather it and try to defend should you end up in the courtroom for any reason. Here are some examples of reasonable accommodation that you may have to do. If an employee is asking, hey, I need you to restrict my job a little bit, I need you to provide that chair, I need you to move my desk out of the sunlight, etc. Whatever that might be, you might have to make some modifications so they're not restricted in performing their job. You will have to potentially give them time off. A lawyer recently gave the example where an employee has very difficult time sleeping at night. So they asked, hey, can I come in 2 hours late? So coming in 2 hours later and maybe staying 2 hours later in the evening certainly is something you might be able to accommodate. You can change them to different shifts to accommodate maybe their inability to sleep, etc. So this area would be really hard to prove an undue hardship. That's where, if you feel that the request for time off is not reasonable, that's where you would want to get a lawyer involved so they can guide you through this process. Like I said, you might have to change your schedule, put them on second shift temporarily or permanently, and it's your right to do that. You might have to modify some equipment. You may have to modify a policy. That's a little scary. And so this is an area where, unfortunately, the judge, if you will say, hey, no, this needs to be modified. You have to change your policy that now work hours are a little more flexible, etc., and allowing that individual potentially to work at home. So maybe you had a policy where nobody could work at home previously, but now you have to adopt that and allow people to do that if that will accommodate their disability. There's another website for you to be able to research this further as to other examples of reasonable accommodation. Now I'm going to answer your question for the poll question. So those individuals who answered no, the 43%, you are correct. Changing a supervisor is not a reasonable accommodation for a disability. You also do not have to monitor their medication. You don't have to lower your production standards. They need to perform to the best of their ability. And you don't have to provide hearing aids, wheelchairs, etc. So more examples are available at this website. And when in doubt, seek advice from a professional that can help you properly plan and accommodate or not accommodate your employee. You might have to reassign an employee. So for instance, they were out on FMLA. They now are asking for reasonable accommodation, which might be a change in position. You could potentially have to put them into a vacant position without interviewing other applicants. So if they request to be reassigned to this open position, you have to put them in there. However, there is an exception that if you have a seniority system that's uniformly applied, you could potentially give a more senior person that vacant position. Now, what this does not mean is you do not have to promote this individual into a higher position. You also don't have to bump somebody else out of a position based upon trying to give this individual a reassignment. So again, this is a scenario where you would want to look at all the facts. It's a case-by-case basis and potentially reach out to a professional to help guide you through this decision-making process. And that's why I said it could be very difficult, some of the decisions you have to make. And as such, you want to make sure you're proactively preparing to be able to defend that decision should you need to. We touched on undue hardship a little bit earlier, and certainly, the Department of Labor recognizes that, it can be costly sometime or compromise workplace safety, decrease efficiency, could impact other individuals, and they certainly don't want to put you in a position to do that. So you could potentially claim undue hardship and not accommodate that individual's request for a change in their work environment because of their disability. I will caution you, though, this is very hard to defend in court because they will try to exhaust all means possible to accommodate this individual with a disability. So if you feel that the request that has been made will put you in an undue hardship position, contact your lawyer immediately because they will help you. I promise you, I know that lawyers can sometimes be a little costly, but it will prove valuable in the end. I promise you that. Just as we did with the FMLA, we talked about some of the mistakes. We also here want to highlight some mistakes that could be made with the ADA, so I want to help you maybe avoid these. You cannot require an employee to be 100% healed. It's unrealistic. You need to consider the reassignment. You cannot ignore it and you cannot deny it. You do need to consider it and offer it, provided you have the ability to do so and you don't have that seniority system we talked about. Don't terminate your employee if you anticipate they need leave, FMLA or disability leave, etc. One example that you might want to think about is, let's just say an individual needs unpaid leave prior to meeting their PTO eligibility. You can't terminate them. You have to allow them to take that time off if they truly have a disability that falls within these guidelines. If you don't allow that individual to have a little bit more time to accommodate that disability, you will look negatively in the courtroom. So certainly if you are asked to give them just one extra week, do it. Because if you don't, the court would say, hey, that was a reasonable request. It really didn't hinder you. You're not paying them. You do have maybe some work that has to be consumed by somebody else. However, it's not truly an undue hardship to you. And one thing you want to make sure is that if you have a third-party provider helping you with your short-term and long-term disability, make sure they're using the proper ADA verbiage in their communications to your employee, because you certainly don't want to be held responsible for something they do or do not say that meets the guidelines under the ADA. So how can you prevent being faced in front of the EEOC and having to go to maybe mediation, counseling, or actually go to court? Follow the law. If you qualify for FMLA, if you fall under the ADA because you have more than 15 employees, follow the law and keep documentation. That is going to be your safeguard and your best defense, and have your lawyer on your side, giving you advice or helping you guide through some of those difficult decisions. If a complaint is filed against you, don't panic. It doesn't mean that it's true, but you will have some work ahead of you to be able to respond to the complaint and potentially go to mediation, etc. So this is a point that if you're notified that your employee or former employee went and filed a complaint, contact your attorney immediately. Because up front, they may be able to help prevent you from getting to the courtroom. And throughout the whole process, you want to cooperate. Do everything that the EEOC asks you, because then it will only play in your favor as you move forward if you have to through the process. There are some small business tax credits available to your organization based upon disability accommodations you make. I certainly am not an expert in this area. There's other tax credits that you may be able to take advantage of. So certainly if you feel that there's an opportunity for you to be able to get some tax credits or you're unsure, I would be happy to put you in touch with Tom Mao. He is a principal here and leads our Strategic Tax Services group, and I definitely think that he could help you at least analyze if there truly is opportunity for you to get some credits with your taxes. Now we're going to shift to workers' compensation. We have about 15 minutes left here. I think we definitely will have at least 5 minutes at the end to answer some of your questions, so please be patient here. But there are times where you may have an individual who goes out on a workers' comp scenario, they're injured at work, and then it turns into a disability. So I thought I'd walk through a scenario here where you can see how this truly could overlap in and of itself. So you sit back and you imagine you went out to eat at a restaurant at 6 o'clock, it's busy, the restaurant's packed, there's people waiting, and all of a sudden, employee faints. And other employees say, yeah, I've been, dealing with a headache, I feel a little dizzy, etc. And you realize, uh-oh, we have carbon monoxide poisoning in our restaurant. So immediately there are things that you need to be doing, and we'll talk about those action steps shortly as we move forward through the scenario. But let's say the dust settles, we've done everything we need to. Now those individuals who were in the restaurant have some memory loss, have some issues with thinking and concentrating as a result of carbon monoxide poisoning. Now you might have to, because this was a work comp claim, you might now have to accommodate them and their disability under the ADA as a result of this event. So knowing your rights, your responsibilities when those lines kind of get blurred is so very important, just so you proactively can take the right measures. A few things that I'm sure all of you are familiar with or aware of, and just want to make sure that you adhere to these work comp facts. Safety is always first. Make sure you don't tell your employees not to report themselves getting injured. I know my husband, he's like, I don't need stitches. I don't need to go to the doctor. Well, unfortunately, that could lead to an infection. It could lead to many other things. So you got to put your foot down and make sure that you're forcing them to go get the help that they need. Whether it's not necessary, I'd rather do that than to find out that it becomes a bigger issue, which then requires more medical attention, etc., and just increases your exposure and liability under workers' comp. You do want to encourage the reporting of injuries. It could be nothing, but I'd rather be on the side of caution and just be aware of what's happening within my workplace and making sure employees feel safe to come forward and report injuries. And partner with your insurance company, because they can give you tips and tricks and measures that you can tell to keep those work comp claims down. They also offer a lot of times free training or seminars or safety supplies, etc. So definitely view them as a partner, not that person that you want to keep at arm's length because you're afraid they're going to increase your premiums. So keep that in mind as you move forward with work comp. But if you're faced with a situation like the carbon monoxide poisoning, it can apply to any business, really, anywhere that you have a boiler or some type of gas heated element. You want to stay calm and you want to remain neutral. You certainly don't want to give off the impression that your employees, you're like, well, they're making it up. No, I mean, you might think that, but certainly you need to remain neutral. You need to take it seriously, stay calm, because that calmness is going to help you carry through and make sure that people don't panic. Execute your emergency response plan appropriately. Call the authorities, get the ambulance there, call your marketing team to make sure that you can do damage control from the news media perspective. You want to make sure that everybody's safe and cleared out of the building. Lots of things that you want to include in that emergency response plan. And if you don't have one, prepare one now. Put it on your to-do list with your FMLA policy, because in the time of need, you're going to need to be able to just stay calm and execute that. If you don't have a response plan, it just can further compound the issue. You want to remain neutral and investigate thoroughly. You want to document all parties involved. Your insurance company definitely will be a partner in this to help you. You might even have to have the police help you. You don't want to retaliate. So your employees now that were in the building at the time that the carbon monoxide leaked, they now need to seek medical treatment. They say that they're having complications. Don't fire them. Don't retaliate against them, because now it could fall under ADA. So you need to accommodate their requests as long as they're reasonable. If an individual has excessive absenteeism and truly didn't prove that they have a disability, you can discipline. But again, this might be one of those hard decisions you want to consult a professional or an attorney on. And what lessons can be learned as a result of this incident that happened in the workplace, not only from how you responded, but could have it been prevented, could have the equipment been serviced better, and what are you going to do next time you're faced with a similar situation? Preventative measures, as a result of those lessons you learned, what else are you going to do to make sure that the incident isn't as painful or cumbersome, or that you could execute it a little more seamlessly? And we are going to round out this webinar with paid sick leave. This is, in some states, now mandatory that you have to provide paid sick leave. So at this time, FMLA does not require you to pay employees for the time they're away. The ADA does not require you to pay them for time that they're away. However, maybe the employee does fall under short-term or long-term disability, so they could receive compensation potentially from the insurance carrier. And some companies will allow employees to utilize their accumulated sick time or paid time off or vacation time to receive compensation during the time that they are off. So be in tune and in touch with your state, your city. At this time, Pennsylvania doesn't require it. However, Montgomery County and Maryland, it does, so it's becoming closer to home. So you want to make sure you're plugged into someone somewhere that will keep you alert to any paid sick leave rules that go into place where you conduct your business. And the nice part about it is that sometimes you can just include that mandatory paid sick leave all in your current PTO policy. So if you're faced with a situation, you might want to evaluate that and determine if it does fit within PTO, because then maybe you don't have to outlay any additional time. And again, you want to implement a reliable tracking system, such as a spreadsheet or your time and attendance system, etc. That way you can truly keep track of the time that your employees are away from the workplace, the time that they're getting paid, and maybe the unpaid time. So that is the end of the webinar. I hope you found it informative, if you will. I certainly wish we would have had more time. We could have dug deeper into these areas. So if you do have follow-up questions or scenarios, I'd be happy to jump on a call with you or meet with you in person to discuss them in more detail. I am going to open it up to questions now. Lois is going to share with us some of the questions that came up. Looks like we have about 8 minutes or so before we close out the webinar and then get that survey ready for you to complete.
All right. I think we have one that they might not have been on at the beginning. They want to know if we're going to send out the PowerPoint presentation.
Yes.
Okay.
For those of you who have not attended a Stanbone Nest webinar previously, we go ahead and send out the presentation to not only the people that did attend, but those who registered and were unable to attend. We then make these available on our website under the events section, so you can view it at a later point in time.
Okay. And then we had 2 people ask, do you need a written FMLA policy if you have under 50 employees?
No, but what you might want to do is include verbiage within your handbook indicating what the FMLA law is, and that at this time, you are not a covered employer under the legislation. But I definitely encourage you within your handbook to at least tell them what it is. That way that they should truly know, especially if you're not close to the 50 employee mark, that they know they don't work for an organization with 50 employees.
All right, and then related to ADA, does that 50 employee number apply for ADA?
No. So I do apologize. I thought I included it on one of the slides. It was in my blog that we sent out a couple weeks ago, but under the ADA, it's if you have any employees, 15 or more employees, then you do have to abide by the ADA. So it is different. FMLA is 50, ADA is 15.
Question under FMLA, you stated that employers must continue medical insurance. If the employee contributes towards the premium but now does not receive a paycheck, how would that be handled?
That, unfortunately, you can send them a letter or an invoice, because maybe they have a spouse that is earning compensation that could pay that. Otherwise, you will have to obtain that from them once they do return to work and they do start earning compensation.
All right. Another question, do part-time employees count towards the 50 employee number under FMLA?
That's a really good question. I apologize, I don't know the answer. On the safe side, I would say yes, but I'd have to verify that. I do apologize.
Okay. And if you accrue paid time off, Do employees, and you have employees on FMLA, do you need to continue accruing their time while they're out? Now, they're not talking about intermittent time off, but if, say, they're out for 6 to 8 weeks.
That's where you want to review your policy. So I would look at your policy and make sure that it does say that the time is accrued on hours worked, because then FMLA is considered unworked hours, very similar to like overtime calculation. You don't have to calculate it on paid time off because that is unworked time. So I would incorporate that in your policy, because there is no law out there saying that you have to continue to accumulate that during the time an employee is out. However, if you have somebody currently out now and your policy doesn't state one way or the other, then you should err on the side of caution and award it and make that policy change, effective today or 8/1, and then going forward, anybody who would go out on FMLA, they would no longer be able to earn that time off. So it's really your decision and what your company wants to do within your PTO policy.
We have a question on workers' comp. What about employees who are injured as a direct result of their failure to follow your safety procedures? Isn't this still workers' comp claim?
Yes, unfortunately, even if employees don't follow the protocol, you will have to submit a work comp claim. It's up to the insurance company if they want to deny, any of their medical coverage, etc. That is a decision you don't want to make. However, what I would do is discipline that employee for not following your policies and procedures. You absolutely have the right to do that.
All right. How about a workers' comp claim when the employee is taking time to go to the doctor? Do you have to use sick time for that, or do you just pay them regular pay for the time where they're going to the doctor?
It depends if they're salary exempt or hourly. If they're hourly, I would make sure they clock out, and then if it's not a work comp claim and it's just truly related to a disability, you don't have to pay that. Under the work comp, that's where maybe the insurance company might pick up that missed compensation for not meeting the 40 hours in a work week. So I would reach out to your work comp insurance carrier to see how they handle that and what their rule is for paying individuals going to the doctor during business hours when it's related to a work comp claim.
Okay. And is there any difference in the treatment of exempt or non-exempt employees for FMLA?
No.
Okay.
All treated the same. So whether you're salary exempt or hourly, for FMLA you need to treat them all the same. However, if that individual only works part of a week, we would really have to look at whether or not it was due to their own accord that they need the time off. If they got injured, let's say, playing volleyball on the weekend, or if it was related to, another scenario like an illness. We'd really have to look at that as to whether you had to pay them for the full week. As to when they went out, obviously subsequent weeks you wouldn't have to pay them, but you'd want to look at your unique situation.
All right, here's a question on ADA. Is obesity considered a disability?
Eating is one of those areas where it could fall. Obesity in and of itself, I have not seen one way or the other. I think it really would come down to whether or not the obesity is related to something else that falls within that disability. So if they have something else, maybe thyroid disease or something like that causing the obesity, so that's where you would want to get the certification from the healthcare provider, and you would want to get them to elaborate and to confirm that it truly is a disability. That you might want to get your attorney involved.
And we have one more question, Christy, that says, what happens when you have to fill out the FMLA paperwork after an employee returns from a week-long medical absence?
So it sounds like maybe they didn't tell you in advance that they needed the time off, and so there is a 30-day window where they need to give you notice. However, they have that special clause in there, or as much time as possible. So if somebody's in a car accident, obviously you can't plan or prepare for that. So just follow through and get the paperwork completed as timely as possible. And make sure you keep a record of when you send out notification, how you were alerted of the or illness, etc. Keep all of those dates and timestamps because that will be very important should you have to make a decision to not offer FMLA because that employee didn't fulfill their responsibilities with respect to getting the notices back to you in a timely fashion.
Well, as you can see, Christy has an awful lot of knowledge about this, and if you really need a deeper understanding of any of these types of policies or procedures, I really encourage you to reach out to her for help, because she's just here waiting for you to ask. And sometimes part of the process that she does is called a Human Resource Business Process Assessment, and often in that process she will reveal some issues that you might not even be aware are missing from your handbook or the whole procedures that you do in your whole human resource department. So I'm just saying, you know, reach out for help, because I know she knows a lot, and we all can learn from her.
Thank you, Lois. And looks like we don't have any more questions. However, you do have the ability in the survey to put some questions in there as well. So if you think of something in the survey, please do that. My contact information is on our website, so frequently I'll get emails days, weeks after a webinar with somebody who has a follow-up question. So I hope you were able to find some value in this webinar today. I want to thank you for participating, and I look forward to speaking with you next month on our webinar at the end of August. Have a great rest of the day.